Hello, and thank you for joining our webinar today entitled Privacy and Security and How Does GDPR Change Things? My name is Neil Begg, and I'm a principal in the Risk Advisory Services practice of Cherry Bekaert. We assist clients with all things compliance, security, and privacy related. And when GDPR came on the scene about a year ago, we realized and admitted in-house we did not have the expertise as it deals with privacy in the European Union. So what did we do? We decided to seek out the best and partner with them to help our clients. So for the past year, Cherry Bekaert has teamed with Richard and the folks at CPG to assist clients in adhering to this new regulation that is GDPR. I'm happy to be joined today by Richard Purcell. Richard is the founder and CEO of the Corporate Privacy Group. Richard founded CPG back in 2003, and prior was the Chief Privacy Officer of a small company that some of you may know called Microsoft, as well as held positions as Chairman of the Homeland Security Privacy Advisory Committee. Richard, really appreciate you being here. Thanks for joining us.
Neil, thanks for introducing me. I'm really happy to be here today. I'm really thrilled to be with Cherry Bekaert and to go over the GDPR requirements for your clients.
Here we are in the middle of the summer, 2018. The deadline is passed. So the thought is, why are we doing this? Why now? Answer is, people are obviously still interested and still need additional information. There will certainly be organizations, some already clients of both Cherry Bekaert and CPG, and some future clients of Cherry Bekaert and CPG that will need to comply with GDPR. So before we jump into that actual standard, what I was hoping we could do, Richard, is kind of give a little bit of background on the global view of privacy and more appropriately, how the rest of the world views privacy versus the United States. How's that sound?
Yeah, it's good. So the rules behind privacy have been promulgated over the last 20 plus years, and in the US the basis of data protection and information privacy is considered a reasonable expectation as stated by the Supreme Court. Despite the kind of weak words, reasonable expectation, that might imply, there are robust sets of laws and regulations in the US, particularly applying to specific sectors of the economy, whether it's financial services, education, or medical and healthcare. These are generally enforced by the Federal Trade Commission and rest on principles we'll talk about in a minute of transparency, fairness, and truthfulness. Now, to create the difference with a distinction to the European Union, privacy there for the last 20 plus years, 30 years almost, has been regarded and actually put into law as a fundamental human right, tantamount in the United States to the fundamental human rights contained in the Bill of Rights and other constitutional amendments. There are very strong laws and regulations in the European Union, and rather than the US case of sectoral application, these apply to all the processing of personal data in the EU, and is also enforced by specific nationally based data protection authorities, as well as interpreted and aided by a European Data Protection Board. So it's this more overarching and frankly more fundamentally applicable legal structure to privacy and data protection in Europe. Now, in the rest of
Oh, yeah. Sorry to cut you off, Richard. So my thought there is, it seems apparent that the USA is almost a little bit behind, if you will, in terms of privacy law compared to Europe. Obviously, we've seen some things in the United States dealing at the state level or even by given industries. You mentioned healthcare and so forth. Is it safe to say that Europe is kind of leading this path in terms of protecting their citizens' data with this GDPR, with the regulation?
I think that's fair to say. I think that a fundamental difference is that in the European Union, let's be frank, the European continent has experienced over the last 50 years enormous disruptions based on the use of information in a very, very dramatic way that resulted in death and destruction across the continent. So, I mean, there's a reason for their history. Secondly, they have a different approach to kind of government services than the United States does, where government services have had a longer period of history and government regulation has been more profound in utilities and other areas. The US is, largely run on a, you can do it until we tell you you can't do it basis. Well, the European Union is, no, we're going to tell you what you can do. There's a certain trade aspect to the US basis that isn't quite as profound in Europe. Some pretty distinct differences.
Excellent. How about some other countries?
In the rest of the world, a lot of the Commonwealth countries, first of all, prior colonial areas, have adopted a lot of European standards. Canada, Australia, Argentina. That additionally, the Asian countries have really gotten a lot of, I would say, strong to robust laws and regulations. Japan and Korea, Singapore, China is emerging as writing a number of laws, much more about security than privacy, but still have that effect. South America, not so much. Argentina for one, but then in these others with very moderate laws, Egypt, Turkey, South Africa, Mexico, Russia, they have a mix of laws that are really not very strong, but actually do exist. So if you look across the whole world, there's a tremendous disharmony. There's a lot of mix. There's not a lot of unification theory there. That's why the GDPR kind of begins to make a difference, and that's why we're having this discussion today.
Excellent. Well, that's great background again on that landscape. One of the things I think would be pertinent to dive into now that we have kind of that grander picture is, before getting down to the level of GDPR, can we talk a little bit about the basic principles of privacy, and then maybe how does GDPR change things?
Sure, and things have changed and they haven't changed in some ways, Neil. So the basic principles of data protection and privacy were laid down 30 years ago by the OECD, and they include things like transparency. Tell me what's happening here. Tell me what you're doing, what you're collecting, etc. Limit the amount of collection that you're doing. Tell me exactly what the purpose is and stick to that purpose in a narrow sense. These are some of the basic principles, and these still exist even in these laws that we may consider more moderate as opposed to robust. If we look at the next slide, there are more though, because there are limits to the use that you can apply data to. There are requirements for individual participation, meaning show me what you have about me. Tell me what kind of information you have about me, how you're using it, who you shared that with. Let me as an individual be part of this, deal, this processing. You have to protect this data. Security safeguards are one of the things that have emerged over the last 20 years in more profound ways. And then finally, and this is where I think we get to a good transition point, because this last point of accountability has not necessarily been the strongest principle in application, but is becoming very strong. And in fact, accountability has risen to prominence under the GDPR as one of the strongest principles to be enforced. Now, GDPR enforces all of these principles and more, but accountability is now becoming the key word, because frankly, it's as the internet age has rolled forward into our lives and has become so embedded in our lives, the question has become, an individual is very unlikely to be able to control their information. Once the information is provided to someone else, another party, company, website, whatever, that information control is gone. So the accountability of managing that information now rests with the website, the company, the people who collect and use this data. And so accountability is becoming much more a part of the fabric of the principles and underlies, like I said, a lot of what the GDPR requires.
Interesting. Obviously, accountability, even as a buzz term, if you will, taking off in government in recent years and in corporate culture and really between relationships in general. Another buzz term that has come to light in recent years, along with this upshot in security and privacy, is PII, personally identifiable information. As it relates to GDPR, is PII still defined the same way, and how does GDPR define personal data?
So in both the United States and in the European Union, the definition of personal data has been expanded and incorporates much more than it used to. So when I started this, and I've been doing this for a while, I've literally been doing this for over 20 years, personally identifiable information was, of course, the term of art. And we were trying to get to, yeah, it's like a name, it's like this, it's this and this. I'm trying to say it's these discrete things. We're trying to really build a boundary around it so we could get our hands on what we were talking about. Well, obviously, the amount of information that's been collected and used over the intervening 2 decades, and particularly by massive globally operating companies, has made that very much more difficult to do. So now we're not using any longer the personally identifiable information so much. We're using personal data. If it's about a person, it's probably personal data. So we're just saying, can you identify in any way? Can you use this information to identify or to create an identity for an individual? Which links in stuff like, okay, IP address all of a sudden is becoming personal data. Biometrics are personal data. Even if you don't have the personally identifiable data immediately, if you have a bit that allows you to get to the identity, then it's personal data. Everything is personal data. I always talked about it with people. It's like you've got a bunch of data, and a lot of it just starts glowing because it is either identity data or linkable to identity data, and so it all becomes part of the personal data definition. And GDPR, along with the Federal Trade Commission in the United States, GDPR expands the definition of personal data. If it's about a person, it's probably personal data. I can't say Neil is personal data necessarily, but if I say, yeah, Neil, who works for that firm in Richmond, that is, it's a big firm, it's got this name, all of a sudden you say, well, yeah, okay, well, that's Neil Bekaert. So Neil Bagan. So all of a sudden, it's personal data, even your first name.
Excellent. Yeah, and what's interesting about that is, you kind of started off talking IP address and biometrics, and you start thinking technology and so forth, but really some of these categories are far less technical and can be, if I'm not mistaken, everything from even kind of frequent flyer miles, who you're flying, to hotel stays and memberships and so forth. Is that right?
Right. Yeah. If you can use a little bit of detective work and take a bit of data and find out who it belongs to, then it's personal data, and it has been personal data since you first acquired it. And some of that has higher risk than others. So we define certain categories of data as special categories because they present, when abused or misused, they present a higher risk to the individual of some kind of harm or loss, like, could be reputational harm, could be financial harm, could be any other, could be security or safety. So, the listing here is, money, your health, the genetics and biometrics. Keep in mind, you can change. I'm Richard Purcell. I can probably find a way to change my name and kind of go into hiding some way or other. I don't know how I do it, but I could probably if I just change my personal data. But I can't change my iris scan or my fingerprint or my DNA. That's something that is unchangeable. So to the degree that people have that kind of information, these special categories have particularly robust overheads and regulations around them for care. The standards of care on these are much, much higher. You have to have explicit consent even to collect it, much less and to use it. And the security safeguards you have to put around it, they're higher. That's all there is to it. You just have to be more careful with this stuff.
Understood. Absolutely understood. Well, great background. Have a little bit more insight into landscape globally, into the principles that kind of govern privacy, if you will, and then kind of digging down a little bit more into personal data. So as far as GDPR goes, with all of this background, who does this apply to?
Yeah, it's a great question. There's this, in data protection, there's this kind of dividing line between what we call controllers and what we call processors. So I'll start with that. So just to get an idea, in the world, there are controllers and processors. Controllers are those people who have a first-party relationship with the individual and the data. They determine what we're collecting, what we're using to collect it. How are we actually managing the relationship with that data subject, and ultimately the controller is responsible for the rights of that data subject under whatever enforcement mechanism, wherever that geo-jurisdiction is. So the controller's like the one-on-one to the data subject. Now, everybody in the world probably by now has processors. You have people who are helping you to do the work. You're hiring out this stuff. Those are the processors. Those people don't have the direct relationship. They probably, or they might not be the ones who collected the data. They certainly aren't the ones who decided to collect the data. They're doing it on behalf of somebody else. But they're responsible for upholding the obligations that are their controllers, usually their clients, their obligations. They also oftentimes they'll be the first party to actually receive requests or inquiries, and they're not really in a good position to answer those inquiries. If I'm processing data for some financial services firm and they call me and say, well, what about this or what about that? I go, whoa, wait, I got to refer you to the party that owns this relationship, my client and the person selling to you. So generally, they're not allowed to change records. They're not allowed to be directly communicating with the data subject unless it's after training and under a contracted requirement of the controller. So the processor is responsible for all of these obligations on the controller's part, but is largely kind of secondary to actually talking directly to the data subject. There's lots of other kinds of hybrids available in under this model as well.
Yep, and that was one thing I was going to point out. As Cherry Bekaert and CPG have helped various organizations with GDPR compliance over the last year, the question inevitably has come up: can an organization be both a controller and a processor?
Well, they absolutely can. So a processor who has employees in the European Union is a controller of the employee data and a processor of the client data that they may have contracts for. We can have controller and controller, joint controller relationships. So, if I make chocolate bars and distribute them through a retailer, we may both use our customer list. We may both use, take the data and share the data, and we might both have a controller relationship, which makes things really, really confusing. There's a lot of hybridization going on, and we can only expect that will continue and get a little more ambiguous. These roles will begin to morph into each other even more than they have already.
Absolutely.
And we expect that that's, just how, because the technology takes us there.
Absolutely. Well, let's dig a little bit into GDPR itself, this one law to rule them all, if you will.
Yeah, so GDPR, as I said earlier, it takes accountability as its primary principle that it's trying to enforce here. So it's essentially saying, look, if you deal with personal data and you're under the influence of this GDPR rule, which we'll talk about, you have to do certain things. And these are enhancements to the former directive that the European Union worked under. It also, and the most important thing is, it's much broader in applicability than it ever was before. So if you're a company, you don't have to be in the European Union, but if you're a company that's offering goods and services in the European Union, and as a result, you're collecting data of European data subjects, you're responsible for this. Now let's be clear. If a person from France is in New York City and comes down with a case of appendicitis in New York City and goes to a hospital, that hospital is going to treat that person under US law, which would be, in this case, for privacy, would be HIPAA laws, not GDPR laws. So the entity that's treating the person is controlled by where they are and where the person is in some combined way. So if I have clients that are in Europe and I have their data and I bring it to the United States, I'm responsible for handling that data under GDPR requirements because I got it from them while they were there and I was selling services to them. I don't have to be in the European Union physically in order to be subject to GDPR. Now there's a much longer story about exactly its scope and applicability, but in general, if you're offering services and they're being absorbed in Europe by European citizens, then the European Union laws apply to you in GDPR. The penalties are severe, so don't mess this up, because 20 million euros or 4% of annual worldwide turnover is the maximum penalty, but it is, of course, an enormous hammer to hit people with. We'll see if those substantial penalties come along. We don't know. Right. But there are reasons to be very cautious around this.
Yeah, and completely agree there. We'll be interested to see what happens now that this initial deadline has passed. One of the things before we move off applicability that I think it's important to communicate on this webinar, oftentimes when we are approached to help with GDPR compliance, one of the initial questions is, we only process or collect or control this many records, or only deal with this one country. Does this apply to us? I mean, is there any sort of threshold whether or not you're processing 50 records or 50,000 records of European citizens?
In legal terms, no. That'd be a little bit like saying I've only got a pint of gasoline here in my bedroom. Does it? It's not much. Does it matter? Yeah, it matters, because there's a certain volatility. Now, Neil, in practical terms, the volumes will probably make some difference. Here's the deal. If you treat personal data in a way that is respectful of the privacy principles we've talked about, more than likely you won't have complaints about it. You won't have, people won't notice that you are or are not compliant with GDPR in its most kind of finely detailed ways. But if you mess up, it doesn't really matter that you're only processing a small volume comparative to your overall processing volumes. If you violate the rights and freedoms of a European citizen under GDPR, then you will be out of compliance, and the local data protection authority will more than likely investigate that.
Excellent, great. So now we come to the good part.
Yeah.
Now we know who it applies to. What I'd like to walk through, we've come up with kind of 8 things that organizations actually need to do for compliance. So I'd like to start walking through these 8 things here. We've got a slide designated for each one, so I won't necessarily jump into describing all 8 now or having you do that, because we're going to go through one by one, but these are really what we've boiled down to 8 things from a requirement standpoint that all organizations that must adhere to GDPR should go down this path.
Of all the things you ought to do, you got to do these things, and you got to do them. You got to get them in place quickly here. So, do you know where your data is? This is all about data governance. Do you know how you get it, how you process it? Do you really have a legitimate and lawful reason for having it? Is it accurate? Is it up to date? Is it relevant to the purpose that you've stated? Have you made yourself familiar with the laws of the countries or regions, the categories, as we talked about, the special categories or sensitive data categories? Have you had a legal review? Have you had your privacy statement, the notice that you post? Is it available? Is it complete? Is it up to date? Does it really represent the truth about exactly what you do? Or does it understate that truth, which could be a very big problem for you? So data inventory and reporting, this is the mapping exercise. Where's my data coming from? Where's it going inside the company? Who has it? How's it being used? Is it accurate? Is it, compliant with the kinds of laws where, that from the countries it comes from? We talked earlier about the worldwide laws. This is not a simple exercise. This is one of the first things. So if you don't have a grip on your overall global operational picture of data, get a grip right away, because this is number 1 on our list.
Excellent. Let's move on to number 2.
You've got to have a legitimate and legal basis for doing this. So, and these rules, GDPR in particular, sets a number of ways that you can achieve that legitimacy. But it isn't all based on consent. It could be a contract for services. You could be just selling something. You might have employees. You may be doing research. There's got to be some basis, but you can't just say, yeah, there's a list of 5. I'm sure to qualify for one of these 5 or 10 or whatever. You can't just kind of throw the dart at it. You have to say, for this data, my legitimate basis is this. And you have to go through and make sure that in going through that exercise, you don't end up with a bunch of data where you don't know why you're doing it. You don't know what your legitimate basis is, because that's the data that will expose you. When you move the data from one country to another, particularly out of the EU and to the United States or other countries that don't have what the EU considers adequate protections, you better have a legal mechanism for doing so. A contractual clause, the certification under Privacy Shield, binding corporate rules, some code of conduct that is to be determined, but we will see emerging. So on the one hand, you have to have a reason for doing it, and on the other hand, you have to have particular legal mechanisms for doing it as well. Look at those things carefully.
Absolutely. A large area, anytime you start talking about security and privacy, is obviously data governance, toned from the top. A lot of questions here. If you could start, I'm going to kind of feed you with 1 or 2 that we always get around when we start talking about data governance. Is from a documentation standpoint, how much documentation do these organizations need to have to comply? And from kind of a personnel standpoint, is it required for an organization to have what's called a DPO, a data protection officer?
Right. Well, here we are in the land of accountability, right, Neil? This is where you end up saying, I can demonstrate to you that I'm accountable for the governance of my data. And the way I do that is I say, look, I've got designated people responsible for this. I've got privacy, security, and records designated people heading these areas. Here are my policy statements, and here are my procedural guidelines for implementing those policies. And they go right, deeply into every part of this governance program. And we look at these on every year. We go through a formal assessment. Some may be internal, it may be external, but we take a look at this. We compare it to the developments that happened during this year of maybe new legislation, new interpretations, new court decisions, whatever. But we make sure that we assess our compliance against that. And finally, we take all of that stuff and we kind of roll it into workforce exercises, and we train our workforce and we educate our workforce to understand that we're obligated to do these things, that we do these things, that we do them according to these procedures. And then we ask those people to acknowledge that they have received that education and training so that we can audit that later. So if somebody does mess up, if somebody makes a mistake or there's some malicious act, we can point to it and say, yeah, we're sorry that this happened, but we have all of this in the background and we trained this person and they ignored it anyway. So, you have a certain level of accountability that is, of course, across a spectrum, but you want to protect the demonstration of that accountability by filling out that spectrum as widely as possible.
Yeah, education is key. I mean, everybody knows it just takes one click from a security perspective to put an organization at risk. So a question here regarding education. One, is it something that's pertinent for all employees, no matter position or level? Would be one. Number two, you mentioned kind of annual, and by that meaning that it's recurring throughout a person's career. It's not a once and done type of exercise. So the second question I would have is, typically now that we would be incorporating this training in, is the idea to mesh it into normal security awareness training for an organization that many are currently doing?
Yeah, though, so we say annual, but that's kind of like at a minimum kind of thing, right? You should be doing it all the time in any case. But those workforce training exercises have to be thorough, comprehensive against both your subject matter and your workforce. So, the receptionist in your affiliate office whose logon credentials are stolen because they clicked on the kitten thing on YouTube creates just as large a vulnerability as if your CIO's credentials are stolen. It takes perhaps longer for the hackers to track backwards and gain more credentials from that low level than it does from the high level, but they'll get there anyway. It doesn't matter. Once you have a thief in your house, you have a thief in your house. And so checking everything, making sure everybody's educated and aware is incredibly important. Those reviews should be done also with external help, because frankly, we're all in the same boat here. We do things right. We've done all these things right. We do things well. We've taken care of all this stuff. You get blinded by your own compliance efforts, and you keep telling yourself, yeah, we're fine. And then some outside expert comes in and goes, oh, wait a minute. What about this? What about that? And, oh, I didn't think of that. The part of this is really use outside expertise on a regular basis in order to make sure that your blinders are not completely keeping you too focused on a narrow kind of gauge instead of a much wider and broader view of the vulnerabilities and the threat environments that you face.
Great. So Richard, we talked about privacy officers and so forth. Let's talk about data protection impact assessments and how these relate to GDPR. We obviously have an example of a template here. So if you kind of walk through this a little bit.
In addition to the accountability principle we're talking about in data protection, the GDPR takes a very firm look at the US promulgated idea that most of these should be risk-based, and this comes right out of the security world. Privacy has had a long history of not necessarily being risk-based. Security has had a long history of the threat environment and measuring risk. These data protection impact assessments are all about taking a risk-based view of the world and the world you operate in. So what kinds of technologies present new risks to me? What kinds of delivery mechanisms, partnering, profiling, or decision-making present risk to me of being out of compliance with some of these rules and regulations? Special categories, we talked about those a number of times. They're obviously risk-based areas. So if I have a site that is both has medical research components to it for sexual behaviors and diseases and conditions, as well as the classifying orientation of different people for their preferences for sexual orientation, I'm deep into a very high risk-based area, and I have to provide specific kinds of mechanisms for getting that, gaining the material, keeping it accurate, keeping it up to date, and securing it by limiting its access and use. So all of those things have to be thought through, and that's the whole idea of what a data protection impact assessment is. Look at all the risks of the type of data, the type of compliance mechanisms, the uses, the access, the sharing and transferring of that information, and do a risk-based analysis of all that stuff in order to mitigate and lower your risk profile to an acceptable level. Impact assessments are increasingly important. They're not universally applicable. You don't have to do one for every single thing you do. There are conditions which indicate you should. There are conditions which say you're probably okay. My own personal opinion, at least a minimal privacy impact assessment for every process you're running is a really good idea in order to keep your management hat on straight and to keep your risk profile in a managed state.
Excellent. We talked about a good bit about accountability earlier. How about transparency in terms of
transparency is, yeah, you know, I mean, tell me what you're going to do and don't lie to me, and make sure that what you say you're going to do is actually what you do. Transparency's been a condition forever in data protection, and we think of it, if you track way back to the Nixon era when people were getting credit and people were being redlined and people didn't exactly know how credit operations worked, that was the beginning of the requirement for more transparency, and it's now found its way into data collection of all kinds. So a privacy notice is a very important part of your transparency. Disclose what you're doing. This is who we are, this is what we collect, this is how we use it, this is how we secure it, this is with whom we share it, or the types of business we share it. All of these things, the who, what, why, how, all of that needs to be very carefully stated and very accurately stated. You don't want to leave out anything because then you're not being transparent, and that could be a case of establishing deception. But you don't want to put in something that you don't do either. You want to be extremely accurate with what you say. People have been hammered over the last several years with cookie notices. My God, I can't believe we're still talking about cookies in this late date, but we are. And there are still notices. There are things afoot that will perhaps give us some relief in the cookie notice area that may develop over the next 6 months or so. But for now, you'll still see those. And annoying as they are part of the transparency thing.
Well, the other thing I would say is, you know, obviously in recent months, there's been a very large social media company that has been to the forefront of the paper some of their practice area.
Right. A failure of transparency, right? And it is, and that's why people feel bad. So it's not all about did you follow. I mean, it is about did you follow the law or not. But it additionally is, have you surprised me? Because frankly, if you surprise me, I'm not happy about that. And surprises can be mitigated by transparency.
Let's talk about some of the rights.
Yeah. Okay. And I know that we're running fast here. This is an area where we could spend an entire webinar talking. We won't, but GDPR is infamous, notorious, or lauded by some people for bringing forward specific rights of data subjects. Now, we've always had the right to review our data. That's not new. That's there. We've had the right to rectify, to correct incorrect data. We now have the right to object to certain processing. I don't want you can have my data, you can do these things with it, but that other thing, I don't want you doing that. So you have the right to revoke your consent for certain processing. That's pretty interesting. You have two of these are really particularly important. Portability. You have, as a European citizen, you have the right to go to, let's say, Facebook and say, I want all of my data you have about me in a structured, commonly used, machine-readable format, so I can take it over to WeMe, a competitor to social media site Facebook, and give it to them. And now I don't have to recreate my history because you already have it. So give it to me. I'm going to take it over a competitor, and we're going to go over there, and I'm going to go be with them instead of with you. That's enormously difficult and a hugely impactful right of the European data subjects. We'll see how that plays out. Erasure is the other thing. You can say, forget me. Now, that's not an absolute right. You can't say, I know I ordered that negligee for my girlfriend, but I don't want you to remember that. Transactions are mostly always remembered for financial and fiduciary responsibilities. But you can say, hey, there's some false information out about me and I want it erased. And once that's adjudicated by the company, they may very well say, yeah, we're going to erase it. They don't have an obligation to notify everybody who has that information, or they may have shared that information with, to erase it. That's up to the data subject themselves, so it's a burden still. But the right to be forgotten is a real right that is in GDPR. And then there's processing restrictions. You can just say, you know what, for now, for the next 2 months, just stop all processing of my data. It's a put a freeze on it kind of thing. And then, we'll talk about restarting it later. That's, again, a difficult operational issue that your companies are going to have to deal with, as European citizens may claim that right.
Great. So in the cyber world, obviously the saying is, it's not a matter of if, it's when. So let's talk a little bit about security breach response and reporting, and talk about some of the requirements that GDPR lays out.
Right. Unlike the United States, which has 50 plus different security breach response and reporting requirements, because there is no federal one, the GDPR said sweeping response requirements. These are Articles 32 and 33, I think. And one is, if you have a breach, and this is an important condition here, if you have a breach and that breach is likely to present some risk to the rights and freedoms of the data subjects, then you must report it to your data protection authority within 72 hours of becoming aware of it. So you don't have to report every single breach. So let's just say, I generated a file of people and I sent it to a processor of record, a vendor that I have, but I sent it to the wrong one. They received it and says, hey, we shouldn't have this file. They destroy it and they confirm that they've destroyed it. That doesn't present a high risk to the rights and freedoms of individuals and probably is not a reportable incident. However, if you posted it to the internet and it was downloaded by you don't know who, then that could certainly present a risk. So it's conditioned. And you have to provide, when you do have a breach and it is risk rich and you have to report it, there are these conditions, as stated here, that you'll have to include in your reporting.
And that's interesting you point that out. I mean, obviously a question that we get from clients is, do we have to report every breach?
Yeah.
Which for some would be impossible. So
Right, right. And the DPAs would be horrified by that because they don't have enough resources to track all that. And we'd end up in the cookie notice area where it's happening so much that we'd get inured and we would stop realizing the importance of the reporting. So there are limits to it and there are conditions around it, and we have to be careful with it. If indeed it is a high risk and you do report it to the DPA, now you're going to have a partner in deciding whether or not to notify the individuals. And if it's a very high risk to their rights and freedoms, then the DPA will probably require that you send a notification to the affected individual data subjects. I guess the bottom line of this is that the GDPR is going to create an enormous amount of pressure to report to the DPAs, and a requirement that you work with the DPAs to decide on what the next steps of notifying individuals are going to be. So you all are probably going to get to be very familiar with your local DPA if you haven't become already.
There you go. All right, last but not least, let's talk about customer service rights support for processors.
Yeah, it's no good, right? It's no good to have these data subject rights if you don't have a mechanism, a customer service support mechanism for responding to them. So somebody, calls, emails, writes to you and says, I think you violated my data protection rights under the GDPR. You better have a mechanism, a trained staff to know what they do. You got to, first of all, of course, make sure that you actually identify and authenticate that the individual making the request is the individual who's subject to the data records. If you're a processor, you better figure out whose client this might, whose record this might be as the controller if you're a processor, and you better follow those controllers' instructions. If it's an erasure or a restriction or an objection request, those are more complicated. And you're going to have to provide a lot more information to the controller than an access or rectification would require. And if it's portability, man, that you better have a system developed to say, yeah, we can write a commonly used machine readable format to, of this person's record that's a comprehensive record, and it is it meets the conditions of the request, as well as including just the information needed and not more than the information needed. It's going to be complicated to do portability, but you need to have customer service support for these rights. And I just wrote this up for the processors because they're the ones who are going to say, God, I don't know how to do this because they don't normally have customer service. The controllers who do have customer service and do have the first relationship, one-on-one relationship, are probably going to be a little better at this, but they're going to be no less challenged to actually come up with proper and accurate and timely responses.
Great. Well, Richard, it's been a pleasure working with you and the folks from CPG for the past year. We're looking forward to continuing our partnership in the years to come and helping clients navigate all aspects of privacy, be it GDPR or the next acronym to come around the corner. I know we covered a lot of information here today for the folks viewing this webinar. We did want to leave contact information. We encourage you, any questions about today's topic, security and privacy and how GDPR changes things, by all means, feel free to reach out to myself or Richard. Again, we really appreciate everyone's time in tuning into this webinar, and we hope you have a great day. Take care.